Hello guys, I hope you're doing well wherever you are and whenever you're watching this session. So today we'll be beginning with our second session of the introductory course. So we will look at different types of intellectual property in brief, but in later sessions we'll look at each one of them deeply, okay? Perfect. So to form a major gist, there are four major types of intellectual property: copyright, patents, trademarks, and geographical indications. Along with these, we will also talk about two intellectual properties, which are industrial designs and trade secrets. Alright, so without wasting any more time, let's jump right onto copyrights. Now, copyright relates to literary and artistic creations, so they can be books, music, paintings, sculptures, films, and technology, and the list goes on. In some cases, it is also known as the author's right. So, copyright infringement means using someone else's creative and original work without their prior permission. Now, here the term literary and artistic works in copyright includes every original work of authorship. So, original is the key here. Now, the ideas in the work do not need to be original, but the form of expression must be. You must also remember this from the previous session when we talked about R.G. Anand versus Dulux film case. Basically, it meant that ideas are free for all, you are free to use, but the expression of those particular ideas must be original to you in order to be protected. You can't copyright an idea, but only the original expression of that idea. Okay, so now let's jump on to the second one, which is patents. So a patent is basically an exclusive right which is granted for an invention. Now, what is an invention? It can be a product or a process that provides a new way of doing something or solving a problem. Okay, so protecting an invention provides the inventor with the legal authority to prevent others from either making, using, selling, or distributing, or even creating without their consent. So patents are provided for a limited time period, which is of 20 years, after which it goes to the public domain, which means that it becomes free and it becomes usable by anyone without having to ask for prior permission. Now, how do we understand if an invention is fit to be granted a patent? Now, there are three prerequisites for this matter, okay? So, the first one is novelty. Now, because it should be one of a kind and it should not be disclosed to anyone, even if it is sold to one person before acquiring a patent, the invention will lose its novelty. Second one is utility, which means that it should be useful and it should be beneficial, and it should also be from the field of technology like engineering or applied sciences. Now, when you think of these terms, you might imagine some very scientific products, but even a regular kitchen product can be patented because even that takes a certain level of engineering behind it, right? And the third one is inventiveness, which means that the invention must be technologically advanced from what is already known to be patentable, or it should have at least one economic significance as compared to previous patented products. Now, let's quickly talk about the third type of intellectual property, which is trademarks. Now, trademarks are all around us. Even the device that you're watching this video on must have Google or Yahoo or Gmail, right? Those logos are very fine example of trademarks. So a trademark is basically a logo, symbol, or even a phrase that is legally registered to represent a company, brand, or product, or even a person, and it distinguishes it from others and gives it a specific identity. So for example, when you see a yellow M, you know it's the McDonald's logo, or if you see a grey bitten apple, you know it's the Apple logo. And did you know that even the word Bidu is trademarked by Jackie Schroff's legal team? It's quite interesting, right? So when we talk about its official definition, a trademark is a sign capable of distinguishing the goods or services of one enterprise from those of other enterprises. Now, trademarks can be either only words or only symbols or maybe a combination of both. They can also be service based like medical, beauty, or agricultural services, or even certification based like you must have heard of Hallmark for purity of gold, or Agmark to certify the quality of agricultural production, or Woolmark for the products that are made from 100% wool. Now, the difference between a trademark and other intellectual property is that trademarks can be given for an indefinite period of time, unlike patents, which have to be renewed every 20 years, or copyright that have to be renewed for the author's lifetime plus 60 years. Alright, now let's talk about geographical indications. So, WIPO describes geographical indications as a sign used on products that have a specific geographical origin and they possess qualities or a reputation that are because of that geographical origin. So, in order to function as a GI, a sign must identify a product as originating in a given place. Now, let's talk more about this deeply to understand. So, any product or process that originates only from a certain geographical area and not from anywhere else, and if the qualities and reputation that this product has acquired is because of its geographical origin, then only it can be termed as a GI or a geographical indication. So, when we give such products a GI tag, it not only promises an authentic and one of a kind identity, but it also promotes the cultural heritage of that particular region. A very famous example of this is the Darjeeling tea. In fact, the first GI given in India was to Darjeeling tea only in 2004. Even the Kolhapuri chappal, which you must know is a type of handcrafted leather slipper, it also has a GI tag which applies to 8 districts in Maharashtra and Karnataka. Recently, there was also a controversy surrounding Kolhapuri chappals, as you must have heard, I guess, when Prada faced backlash for designing sandals that strongly resembled Kolhapuri chappals. Now, Indian artisans argued that it constitutes to cultural appropriation and it is a violation of the GI tag. In response, Prada not only acknowledged that its men's footwear design was inspired by the traditional Indian handcraft, but also visited Kolhapur later to learn about the traditional craft and promised to grant fair credit. Now, apart from these four, like I said, we will also talk about industrial designs and trade secrets. So, coming on to industrial designs first, let's see what goes into that. So, the official definition by WIPO says, in a legal sense, an industrial design constitutes the ornamental aspect of an article. An industrial design may consist of 3-dimensional features such as the shape, or 2-dimensional features such as patterns, lines, or colors. Alright, so basically, if you have designed a product that is unique, purposeful, and distinct in nature, and you have registered this particular design, the IP protection will ensure that no third party can make, sell, or import articles that are definitive or substantial copies of your work. Now, what all can you protect under industrial designs? Now, it is pretty diverse in terms of its scope. So, either textile or electronic goods, you can protect containers or graphic symbols or GUIs and even logos, okay? So, any product that has a distinct design, you can get it protected. Now, coming on to trade secrets, what is that? Basically, information about your business or product that derives its value from confidentiality can be considered a trade secret. Okay. Now, what qualifies your product or business's information as a secret? So, as I said before, first one is the commercial value only. So, what is this information's worth in market? Here, factors like supply and demand, competition, and consumer desire will determine the value. Secondly, the information should be available to a very limited set of people. And the third one is that it should be subject to reasonable steps taken by the rightful owner of that information. Now, it can include either NDAs or NCAs or confidentiality agreements. Okay. Now, a trade secret can also be made up of combination of different elements that are available in the public domain. But the combination of those elements should give a competitive edge to your product or business. A good example is that of Google search engine algorithm. So while a few elements of that algorithm has been made public, the way Google refines its search engine algo is mostly kept confidential. And this way it has ensured that no other competitor could even come close to them. Another example would be that of the method through which New York Times bestseller predict their list. That is also kept a secret. Alright, I hope this session was easy to understand and interesting. I've kept the description of all of these intellectual properties in brief, and in the further sessions, we will indulge in all of them one by one to have a deeper understanding. We will also look at them through the India's legal lens, but before that, we will cover different global and national organizations and conventions that protect and govern intellectual properties. That is all for today. Thank you so much for tuning into Vaquill. Take care and stay curious.